Hey, welcome to the No State Project. I'm your host, Marc Stevens, author of Government Indicted. And, guy, I said to everybody we were going to have a special in-studio guest right here. Look at this guy.
Hey, we're back. So we didn't do Jackalope, but we're here for the Wednesday 1-hour bonus broadcast.
Yeah. Yeah. And are you going to be in Mesa for a while, or is this...
That is the plan.
Whoa, no, that's not what you wanted to do. Yeah, you see what you did to me.
Shutting down the show here.
Shutting down the show.
Minimize that.
Yeah, well, we can do that. There we go. We get rid of that, and we're going to take that right there, all that stuff that you...
I'm going to stare at it the whole time like
a... Yeah, I can't do that, but I do have to watch this one because
there we go.
At Jackalope, you or somebody was helping with that. So, we were able to do the show, and we didn't have to go through because, we get this horrible stream, which I appreciate everyone tuning in, but we get the HD that we'll post.
That's what.
And now you'll get and you see all the blood and guts instead of just.
Now this might be the last show where we're doing it with this camera. From maybe Saturday here, we'll be streaming live directly to YouTube with the new system. We don't have that running just yet, but next Wednesday it'll be up and running. Yeah,
it should be. Yeah, looking forward to that. Plus, the show is automatically going to get more viewers, of course, more people hearing the show because that's where everybody's watching is on YouTube.
That's where the audience is. Millions, if not billions of people on YouTube.
A milestone for this show, we finally hit over 9,000 subs.
Hey, how about that?
So yeah, that was good. I know I was looking forward to that just to be able to do the video with that particular screenshot.
I think the 9,000 mark is going to be a more of a celebration-worthy event than the 10,000. A lot of people, they have those parties on the 10,000 subs, but 9,000 is a good number for us.
Yeah, and there's another NSP, and this guy's site has exploded, and he started doing shows for every 5,000 or 10,000 subs, but he was getting that like every other day. And so he's got over 100,000 subs in just a few months. And so he's got to spread out his celebrations, Otherwise, because if I was doing it like that, we'd have to do something, every day. But, hey, we'll hit the 10,000 soon. And, take it. The show is growing. It's getting there. It's not the easiest sell in the world to convince people that what they thought was true was just a public relations scheme.
Right. Well, it's quality over quantity here. We're not worried about just numbers here. We just want to make sure that we're, getting everyone taken care of. Everyone's getting the material down, and that's the way to go. So it's not all numbers here, as long as we got enough to keep us busy.
Well, we've got people that we are helping with getting success stories, regardless of the 4 people out of the thousands think that what the orders say don't actually mean that. That just because the ticket or the actual motion itself was literally granted doesn't mean it actually was. So we're actually helping people. And so given that, the number is 218-632-9399, 218-632-9399. The passcode is 2020 with the pound sign or the hashtag. It's the same thing, right?
I say pound sign. But, if you're on Twitter, it is hashtag.
It's a hashtag on Twitter. It's the same thing. So so everybody knows what it is. Well, when you call in, you should get that. You can also contact me by instant message first on Skype, and that is at Frank Rizzo 3. And I will say it came up. I don't remember where it came up, but somebody mentioned Brett Weir on the forum, or it was on YouTube. Brett Weir.
That's jerky.
So I would say that if anybody was running for president in 2020, if it was Brett Weir,
he has my vote.
He's got my vote.
Yeah.
I would definitely vote for Brett Weir for president. So, it's interesting because Joe Arpaio recently was found guilty of contempt. There's a lot of irony there.
Yeah, a little too much. I wonder if he'll be wearing pink.
Yeah, he's 85 years old. He was the sheriff for, 25 years. Ever since I've been out here since 93. He was the sheriff when I moved in.
Yeah.
So that it's well over 20 years.
You survived Joe Arpaio. That's worth a T-shirt.
I did, and I will point out that it was in the Madison Street jail and also on I-60 that I was sexually assaulted by one of his by a couple of his police officers.
That might be part of the training.
It was Department of Public Safety that actually did the sexual assault on the street. So I want to be clear about that.
Public safety.
Public safety. And then when it was in the jail, it was by a sheriff. It was by one of his deputies, and he's in control of the jail anyway. That's his jail. The sheriff, Joe Arpaio, was in charge of the Madison Street jail, and didn't matter. Didn't matter. You know, you can file a complaint. It's a cop. They're not going to believe you, and they're going to believe that a woman sexually assaulted a man.
No, it just doesn't happen.
No, it did.
So much for gender equality. Oh, yeah. I'm sure it happened. But
yeah. Oh, and did I just assume the cop's gender?
Well, we did assume, but...
Yeah, well...
Some assumptions are safer than others.
Yeah. Oh, my gosh. That came out... Somebody was trying to make fun of vegans on Facebook and said something about a vegan place that was going to be charging 18% more for men. I thought the whole thing from top to bottom, the article was ridiculous. If that was true, it was ridiculous. The comments were ridiculous, so I couldn't help it. I left a comment, Calvin, that said, are you assuming gender?
Right.
Because the whole thing is it's so stupid. Not that I don't want to spend any real time on that, though. I just remembered Brian Regan, a comedian, saying, you know, how you screw things up in conversation, but if you get someone's gender wrong, there's no recovering from that.
Yeah.
But nowadays, somebody can have a beard and say that they identify as a woman. So what do you?
And then you're wrong for it's a lot of confusion out there.
Let's put it like that. All this kind of, and I'm not going to spend much time in this. I know. I gotta say this. I have to mention this. A certain troll on a website, and this is why. Look, I'm going to preface it with this. Maybe this will be the title of this episode: "When Crazy Jumps the Shark." When you are so desperate in your narrative that you will say pretty much anything. Maybe under the delusion that because someone claims to be a lawyer and educated, that you can say whatever stupid thing you want. He actually wrote, I'm not making this up, but I don't want to give any more attention to this. But I think he's done really well at discrediting himself here. And I say it's crazy jumping the shark because he actually said that the Constitution, which is the supreme law of the land, right?
That's what they say.
That's what they tell me. It's even written in there.
Right.
He actually wrote that the Constitution was metaphor.
Yikes. You know, imagine making that argument in court. See how far it gets you. And really, for me, that's a first. You know, you hear a lot of crazy arguments in court from lawyers, from real lawyers, you know.
Like the Twinkie defense.
There's that. But that it's metaphor, I've just never heard that argued in court before. So if you know,
hey,
like you said, this guy has done a fine job discrediting himself, and
yep,
you know, it should just stand on its own right there. That's, you know, where do you go from there? I mean, you know, it's metaphor.
Yeah, I'm gonna have to put a special place on the forum for him.
Maybe we'll have it on the metaphor section.
Yeah, the metaphor. So the laws aren't. Yeah, I see, and that's the thing. We all get that they use words of art.
Right.
We get that. What they're doing is they're redefining the term. So a person can actually be in the singular or the plural. See, not regular, standard American English, right?
Right.
So we get that. He's not talking about words of art, okay? He's talking about the law itself as a metaphor.
Nice.
Oh, what is it a metaphor for? Do this or we will shoot you? That's more of a veiled threat than a metaphor. So
yeah, it seems like he's struggling with language and syntax. So
I just
metaphor. Wow.
Yeah, and that's the thing.
Take that one to the bench, you know.
Yeah, and just like you, I cannot spend that much time on the forum. I should moderate it better than I do, but I don't spend that much time. And I will say that I've completely wasted my time with that. After you've explained yourself 3, 4, 5 times, you need to give up.
Yeah, I mean, there's not helping some people, you know, especially if they're not willing to accept rationality. If everything's going to be a metaphor, and if they're going to back out of every position, what can you do? You can't do much.
And then there's that standard line that says that every time a court has considered my work, every single time, I gotta watch. You see, I'm more careful because you're sitting right there. Every single time it has been rejected, even though we have demurs that were granted, and we have the motion that was granted. So I keep using the one from Wisconsin because it's so explicit. But even then, it's still it's just because I said it was granted, not because the judge actually said he's granting the relief.
Well, someone's just a little too desperate not to accept something as true. When you have to reach and say never. I mean, nothing's absolute. Now, given that there might be somewhere they just want to, get you out of the court and, whatever. But when you have it written down explicitly that they're granting the motion to dismiss, how do you back out of that? That's kind of a jump. Or jumping the sharks, or as it's said.
When crazy jumps the shark, and that's what happened. Like. And so I only spend some time on this because new people are constantly coming to the website. And I'm not saying don't read this guy's stuff. I mean, but you don't have to go to my website to get this crazy. You can just go to all my YouTube videos and you'll get the same craziness. But you see, the thing is, when people see a YouTube comment, they know in advance it's 99% troll.
Yeah. I mean, YouTube's full of them.
It's full of it. So there's maybe a little more credibility that's given to someone that's on my forum. And while I am inclined to ban somebody who just floods the forum almost 7 days a week, I can't say 24/7, but it is all day long, 7 days a week for weeks and weeks and weeks at a time. Something has to be done.
Especially if it's not constructive, if they're not willing to accept logic or facts and just back out of every position because they don't want to admit right or wrong, then you can't do anything with it and you just have to let it go because you're just going to waste your time trying to prove something right to somebody who's not going to accept facts and evidence. I mean, when you back out and you say it's metaphor, then you can't. It just gives you have nowhere to go. So
yeah, and I want to point out that a lot of this stuff that we're talking about today so far is not something that I've ever heard in court. For them to turn around, I've never heard. You can go to markstevens.net, and this is a good one. This is a good one because I had the similar facial hair at the time. I actually have a 46-minute interview with a man who was professional, Robert Diab, who is a law professor in Canada. And he was very straightforward. The laws don't apply as a matter of evidence or argument. It was a blunt assertion of power. Now, look, I know he's one out of thousands of lawyers and law professors. But he never said it was a matter of philosophy. He never said, well, Mark, when you ask for evidence that a written instrument applies, at least this magical one, then if you don't accept our non-responsive answer, so if you're asking for proof and we don't give you proof, if you call us out for giving you a non-responsive answer, then you are magically turning it into philosophy. These are not made in the real world. Right. I'm sure the troll that is making these comments can't find one citation from any court that he seems to revere. Not one citation that says asking for this evidence makes it a philosophical claim and we can't hear this, or even that it makes it a political claim.
Yeah, he's not going there, and I don't know. You just I mean, honestly, the metaphor is the first time I've heard that. So when you pull that out, and you have no citations for it, yeah, okay. I mean, if that's your position, that's a first. You're breaking new ground there, but to be taken seriously, and I mean, we've talked to Scott Bales. To all these guys, they don't make those particular arguments. In fact,
no.
The chief justices, we talked to, they all generally say about the same thing. It's either what Robert Diab said, it's a blunt assertion of force, or power. Argument ad baculum.
We got all these. Yeah, we have all these. Yeah. So here you have the official position of the Maricopa County attorney. The official position. Now, I have the email on markstevens.net that the reason why the laws apply to me is because they put other people in prison. They didn't say you're asking a philosophical question. Right. They're not saying, and that's the thing. Philosophy has to do with how we know things are true. And we know the things are true because there's evidence, there's proof, there's information that supports and proves the proposition being made. And so for the people who are new, you're not going to encounter these stupid things in court. What you will encounter, and I have examples of this at markstevens.net, I've actually spoken to real prosecutors. And you did a wonderful job of editing, and that was a surprise on the show, where a prosecutor in Washington, a woman, I assumed her gender.
No,
damn it!
There you go again. Yeah.
Damn it! See, I'm too stupid. I can't understand this stupid. So she insisted that the laws applied because he was physically in Washington, and I'm asking for evidence. Why is that true? It just is.
Yeah.
This is a prosecutor with a Juris Doctorate degree. Why? If I'm the idiot, why is the attorney it just does, or it just is? Why doesn't she ever just come out and say? They never say in court, you're arguing philosophy, dude.
Yeah.
Ever.
And we're in, there are rules that say the burden of proof is my say-so, because I say so. Usually they have to have facts and evidence to satisfy their burden of proof. Not that it just is, or because I say so.
Right. And this whole thing that you can use a judge's opinion as if that was evidence, or the law itself as evidence of itself, is totally irrational. When you say a written instrument applies, let's go through, and this is very applicable to any court cases that you're defending against. The burden of proof, like you said, is always on the accuser. They are saying a written instrument. Yeah, they're saying a written instrument applies. Their own rules say that the witness has to have personal first-hand knowledge of what they're testifying to, and they're testifying that a written instrument applies to you. They have to have personal knowledge. They have to have evidence. So I keep going back to the Shaw case.
Where's the metaphor in that?
Just claim it's a metaphor and you don't have a burden of proof anymore. And not only do you not have a burden of proof, it makes it irrefutable. I feel like SpongeBob. Irrefutable. Yeah. So, there's never, you don't ever hear that. But when you look at what prosecutorial misconduct is very clear, okay? I'm not saying that this is the only, or this is what it is, okay? It's in the Shaw. I'll have it down here. The prosecutor, when they argue, has to have facts and evidence, and arguing without facts and evidence is misconduct.
Not supporting your argument.
You're not supporting your argument. The idea that so don't think that a judge or a prosecutor is going to say, Your Honor, can you back this up over here for me? Can you just say that this is true so that this guy is just arguing philosophy at this point? So we're not going to hear these things. So remember, when you're in court, and we'll get to calls in just a moment. Yeah, we're real low budget here, so you don't have a headset.
No, that's all right. We'll get by.
We'll get by. So when you're in court with these things, you have to remember to make your objections. And you're asking questions, and you want to bring out just how unfair it is. If the prosecution is going to make a claim against you, and it forms the very foundation of their case, and goes to the jurisdiction of the court, they have to have proof. And you asking for proof and not getting that proof and calling them out for that non-responsive answer doesn't magically change the nature of the claim being made. And this idea that the police don't buy for a second this garbage. This is another thing. The cop, especially in a mala prohibita, which is the overwhelming majority of charges, and mala prohibita, mala prohibitum is a crime that only exists by virtue of statute. It's only wrong because a politician said so. So there's no crime without the law. And to say that is not a part of it, I can't even process how stupid that is to say that the law itself, which makes the act a crime, is somehow not an element.
Yeah, that's...
I know that they don't admit that. I know they mens rea. I get it. Mens rea. You have to have opportunity and whatnot. I get that. But when you're saying that a completely harmless act is a crime because you say so, your say-so is relevant to whether there's a crime or not. But they don't want you to look at that. It's like, don't challenge the system itself. But that's what we're doing when we go into court. You are challenging how unfair the entire thing is. Whether it's a parking ticket or whether it's a traffic ticket or a possession charge. Which, again, we just got another one tossed out.
And I got to say, congratulations there. That's some sweet activism. I kind of lost count at this point as far as how many dismissals you have. But, maybe Gentry could call in and correct us at some point and ask if, the prosecution's ever said that, his arguments are metaphorical, maybe clue us in, because we've only heard that from one person so far, and we need a little bit of affirmation to make sure this isn't the case anywhere else. Maybe we're wrong, but we just haven't heard it anywhere.
Well, I have been wrong. I didn't have enough information, so we had a recent appeal that I had to post a correction on that. It had nothing to do. On its face, it seemed to have nothing to do with the motion or the appeal documentation. We don't know ultimately because the transcript was never sent in. So maybe it was just it was a wink and a nod. Don't send the transcript in, and just all goes away. We don't know. But I do make the correction when we are wrong. But here with Ginger, no, we're not wrong. And I want to point out real quick, when you turn around and say that there's no other explanation available, no other explanation is even plausible, even though it's the evidence, circumstantial or direct, shows that, then you're just being dishonest. So new people to the site, be skeptical of everything I say and everything that's on there. It has to make sense to you. And don't take someone's word for it that just because they say so. Something is not true just because they say so. Something is not philosophy just because someone said so. And bottom line, even if what he was saying was true, all he's doing is making the case for us that you're in a rigged game.
Right.
You probably want to...
Yeah, sorry about the audio here. This will come out on the recording a little better than it's coming out through Ustream here. But yeah, I mean, just because it says so, and it reminds me with this particular person we're talking about, the saying that the need to be right is a sickness of the mind. And I think this is a good example of it, where we got someone here that's so desperate to be right, they were just pulling rabbits out of hats to try and attempt to disprove something where evidence is in question. And you're absolutely right. If someone's making a claim, if the prosecution's making a claim, the burden is on them to prove with facts and evidence that their claim is correct and that they can support it. None of these prosecutors and judges have ever said, "Well, he gave you a metaphor, so therefore it's proving." So,
when crazy jumps the shark, absolutely, yeah. It's so. Remember, all we're doing is getting the prosecution to verify their claim. Right? That's all we're doing. And that's why you have to get these stupid things. And yes, you'll get some of the stupid ones in court, and they usually back off.
Now, unlike the metaphor, they'll tell you that every time you go to court, that the prosecution has a burden to prove to you in court. And you'll see that before the court even starts. A lot of times they'll have the screen up there telling you what your rights are and what to expect. And that's usually right in the scroll, that the prosecution has the burden of proof, and you're presumed innocent until proven with guilty, not proven with metaphors, but proven with facts and evidence is what they're referring to.
And you're not being proven guilty beyond a reasonable doubt because a judge 30, 40, or 50 years ago said so. If a judge said something, and that's the thing, every case is fact-specific, and that's why we keep going around the same thing. Jurisdiction's a pure issue of law, requires no evidence to prove it's true. However, they just have to show your physical location. That's a fact. So I want everyone to keep that in mind. Challenge, and that's all we're doing. We want the prosecution to be held to their burden of proof, evidence, facts, not legal conclusions instead of facts, because we could do that too.
Sure, yeah.
But we could.
But we're not tyrants.
But the judge, we don't do it because we're honest, but I suggest that people at least bring it up in court. Objection. You're letting the prosecutor argue without evidence? Right. Do I get to do that? And see, and that's something that these trolls, that's why they're just trolls. They never try to explain why we can't do the same thing.
Right.
Because why isn't it a legitimate defense for me to say, dude, you're not accepting my alibi, you're not accepting my evidence, now you're venturing into philosophy land and I can't, or a metaphor.
Yeah.
Dude, it's just a metaphor. Your laws are just metaphors. There's no evidence there. Isn't it more proof that they don't apply to us if they're just metaphors?
I would say so, right?
You tell me a metaphor applies to me? What a 200-year-old metaphor? Oh, come on.
And, the fact that they have a double standard is direct evidence that you're in a rigged game here, because what's good for the goose is good for the gander.
Right, and so we do that as far as bringing out that they're allowing the prosecutor to argue without evidence, and when you go on cross-examination, please keep in mind, when they allow the cop to testify, after they say he's not qualified to give legal conclusions and he's not qualified to actually testify against you, because that's what he's there to do, is to testify that you broke the law, you do the same thing. Pull somebody out of the audience. Say, I got a rebuttal witness for the cop. And they'll scream and holler about 602 does not allow you to put a witness on the stand without personal knowledge being shown first. And then you say, because this is what they'll do. I'm sure you can bring out on cross-examination that the witness doesn't have personal knowledge, but this must be evidence first. So you can turn around and say, but let me direct examine my witness, and I'm sure the prosecution can bring out on cross that they have no personal knowledge.
Yeah, so much for the blind scales of justice.
Yeah.
It's definitely weighted in their favor because they're not holding themselves to the same standard that they hold you to. They want to make arguments outside the facts and evidence. You try and do it, see how far you go.
Right. And that's the thing. Like you just said, it's a double standard. The whole thing is not fair.
Which would be one thing if they never claimed that it was supposed to be fair, but they do.
They
do claim that it's supposed to be fair. So if that's their claim, where's the crime in holding them to it?
Yeah, where is it irrational to hold them to their burden of proof? Because 3 or 4 people like to say that I'm a crook, and I shouldn't even spend the time on it. But we have new people. What am I doing? What are we doing that's dishonest? By telling people and encouraging people to challenge the prosecution's burden, to challenge their claims, and not give them a sacred cow, whether it's philosophy or a metaphor? I mean, the whole thing is a waste of time, and we really...
I mean, I guess you'd have to get rid of the whole profession of criminal defense attorneys if that's the case, because isn't that what they do as well? I mean, don't they do the exact same thing as hold the prosecution to their burden of proof?
Yeah, they tend to.
So are they all crooks? Well,
well,
you might have more of an argument there, but
for different reasons.
Right. But
so just as Rook, we'll get to the call in a second. So basic 3 points of the tactic that I recommend that we use has proven to be effective, regardless of people who say that the motion's never been granted. When you can see it yourself on markstevens.net, is this: we are going to zealously challenge the prosecution's claims. We are not going to give a free pass or a sacred cow to any of the prosecution's claims. 3, we're going to start with the single most important claim that they make, and that is that their magical rules called constitutions, these wonderful, magical written instruments that apply because they say so. We're going to challenge that. And I'd be damned if you can find an attorney that will say those first 2 are crazy or make me a con man. The only time they have a problem is when their sacred cow is in trouble. Right. That's where they come off the rails. That's where they start talking about philosophy and all this other crap, and why they have to lie saying I've never had any success.
So, no, you can only shake someone's reality so much.
Yeah, so look at it critically. Don't just accept someone's word for something. Look at it critically, because you're going to need that when you go into court. Don't hold them up as some kind of legal scholars or scholars in any sense. Every single word coming out of their mouth is a lie, or you should assume that it is, and you should be objecting and challenging them on it. So let's see who we've got. We got area code 321. You're live on the No State Project. What's your name? Where you calling from?
John from Florida.
John, Florida. What can I do for you today?
Yeah. Well, I just got out of court today, actually, and I challenged the judge on whether or not I can get a fair hearing, and she said that she gets paid by the state. Is that the same as being like a conflict of interest?
Well, if the plaintiff is the state and she is getting paid by the state,
the plaintiff,
the
plaintiff is the state. It was for a traffic infraction.
Yeah. I wouldn't call it on to her face. I wouldn't say in court. You know, we're only asking questions and bringing out contradictions. So the way we go about it in court is, am I entitled to a fair trial? Yeah.
Right.
Can I get a fair trial if there's a conflict of interest? Nope. Who do you represent here today?
Yeah, she refused to answer who she represented, and I even quoted some of the state statutes and asked her if she got her authority from the state and the state statutes, and she said yes. And I didn't flat out say there was a conflict of interest, but I said, how can I get a fair hearing if the judge is an agent of the state, the witness is an agent of the state, the plaintiff is the state? How is that a fair trial?
Well, that's great,
or
though.
fair hearing.
He's responding with a leading question, though. How can I get a fair trial if both parties are represented through the same entity?
Right.
So you're doing good about asking questions in response to how is it fair if there's a conflict of interest.
And I think that's good. I would have still have objected because he said that the judge refused to answer who they represented that day.
Oh, okay, I missed that part.
And that's a big
she
clue.
flat out said that she was not a representative of the state.
Really? She said she was not a representative of the state?
Yeah, she said, I do not represent the state.
Say, who do you represent then?
She said she doesn't represent anyone.
Oh, well, okay. How did you follow that up?
That was when I threw in the statutes and where she got her authority from.
Oh, yeah. See, I think a better one is to say, objection. Are you running your own private court now?
That would be a good one.
That's a pretty good one. You probably wouldn't have got an answer to that one, though.
Yeah. She was very, very non-responsive, giving all these. The judicial branch is different from the executive branch, and the whole government spiel.
So okay, so you think it's all different. So then why don't you just answer the question on who you're acting on behalf of today? And if she says no, if she says it's not, she's not acting on behalf of anyone, then of course for those listening, you say, well, objection. I'm a little afraid for my safety now because it seems like are you acting?
Well, when you start getting answers like this, you're asking good questions.
Yeah, and then to ask them if they're operating their own private court, because if they're not acting on behalf of anybody, we got a real problem.
Big time.
Right. That was a good way to go about it. She also told me that I couldn't attack the evidence. She flat out said, you cannot attack the evidence. You can only discuss and ask questions about the 4 charges that were brought against me.
Oh, my gosh. And where in Florida did this happen?
This was in Cocoa.
You can't ask questions of evidence. Wow.
You cannot attack the evidence? So if they introduced a bloody knife, you couldn't challenge the chain of custody and the DNA? What the heck?
Right. I was just as lost as well. When I started asking questions like, did you issue these cause of actions? How many elements are there of a cause of action? I was questioning the cop, and she keeps going. She's like, no, you have to talk about the facts. And I'm like, aren't these the facts? Like, this is the evidence. And then I asked the key question about the presumption of my physical location, and that's when she completely shut me down. She was like, nope, no more questions. You can only ask about these 4 things.
Wow.
These 4 things. And did you object?
Yep.
What was your...
I said I said that she asked if you don't have any other questions, I said if I'm not allowed to attack the evidence, then I have nothing else to say because I'm not allowed to attack the evidence.
Okay, what I want for you and everyone listening, when you get into something like that, when they say things like that, they have discretion to limit cross-examinations to only relevant matters. We all accept that. That's fine. They should. Here, they're not doing that. What they're doing is protecting the prosecution because what you need to do here is say objection goes to competency and credibility in prior statements.
Right.
It is amazing. I shouldn't say that. I'm not surprised, but they always deny cross-examination, especially. That's why I tell people we should just really have 2 or 3 set up, questions to really get you to this point, so you're not getting frustrated and having them say these other things. So instead of the cause of action stuff, that's why I've been telling people you got to go to Criminal 3, that script, which is more current and where you set them up. You have them restate their prior testimony. Did you witness me commit a crime? Right? You can say that. And
Right.
So you determined on your own that just because I was physically in Florida, your laws applied to me, and you had jurisdiction and probable cause to stop me. They'll say yes. Now you got them. You're one step away from a denial of cross-examination without any shame whatsoever, and they do it every freaking time.
It's the E word. Evidence.
Yes. Do you have any
I'm definitely going to be filing an appeal.
Well, you could also file a motion to vacate the judgment based on a lack of evidence proving jurisdiction and that you had denied a fair trial because they denied cross-examination, to turn around and actually say, and you need to quote her in that motion. I have a template I can send
Right.
you.
Yeah.
Say,
I have to get the transcripts from the clerk.
well, not just yet, but for the appeal, you'll have to get that. So hopefully, it was like Ed's in Ohio. It was pretty short. Doesn't cost you thousands. But you definitely want to quote them at this point that you could not attack the evidence and that you could only ask about these 4 things and you weren't allowed to question him on his prior testimony. See, when he says he has jurisdiction to stop you, when he says you violated the law, he's saying that the laws apply to you. He's testifying to that. And to turn around and say that you can't ask questions regarding his prior statements, no. You have to be so corrupt or so dishonest or just so clueless about the system to say that what that judge did to you today was fair, because it wasn't.
Oh, yeah. Brevard County has been known to be corrupt. And, I mean, our local city police officers, their department has been shut down twice in the last 10 years for corruption.
I'm not surprised. And I know guys on the chat, you guys are saying that Florida has a corruption problem. They all do.
Right.
They all do.
Otherwise, we wouldn't be going
Well,
in
I
as
just
much.
gotten involved in our local Libertarian Party, and I really want to, be involved in trying to expose some of this corruption. And it's definitely eating at my craw here with all the corruption down here. It's just ridiculous.
Well, can you go to a city council meeting and ask them a couple of questions?
Yeah. I have to go to a county commission meeting. The only thing that I can talk about at my city council, because I'm not actually a resident of the city, is the water, which I actually just went last night and talked about fluoride in the water, and they presented some bullshit that was, fake stuff. But I have to go to a county commission if I want to address other issues, I guess.
That works, and these are the questions, everybody. I know that you guys operate under the presumption that if I'm physically in Florida, your rules apply, your laws. Remember, the Constitution is the supreme law, so if you just say laws, you're including the Constitution in your question. And they'll say, well, yes, of course, that's how things work. It's not metaphor, it's real. And then you just ask them, do you have any actual evidence, any proof that just because I'm physically in Florida, your laws apply to me? And then just wait.
Also, hey, when you go into City Hall, too, do what you can to get a camcorder in there.
Yeah.
So that we record this and get the responses. It's an open hearing, so there shouldn't be any problem, unlike court where there are, sometimes problems and restrictions with that. With the city council hearings, do what you can to get a recorder in there so that we could post that on the website and other people can see it, how they respond to these questions. And hopefully it'll encourage other people to go and do the same thing, because you got to keep in mind, this is still just as low. This is more low risk than a traffic ticket. So you're not risking much by going and doing it. But what you're doing is you're providing a lot of valuable evidence that they don't have what they say they have, that they don't have the evidence to prove that their laws apply, and that they're operating just on their own say-so, or because they can, or out of violence.
A blunt assertion of power.
And you let us know if they say it's a metaphor, because that we're looking for that one. That's a new one, but we're looking for verification on it.
Yeah, and so the other side of it too, if you have the opportunity, the time to ask more questions, is I wanted to know that since, if I was to operate in the same manner you guys did, if I was to force perfect strangers to give me money, would you consider me a criminal? And you don't need an answer to that question. Everyone's going to know, like, what did the kids say now? Oh, that was savage.
It's a lot of beast mode happening.
Yeah, and so those two you want to get in there. Because people need to see that. They need to see, and I need to be. I did it a few times, and it's just more difficult for me, and it's easier for me on the phone. But you could do it on the phone too. You could just call one of them up, and question him. Look what I called up. What's his name? Jack Smith, I think it was, in here in Arizona. When I asked him those the questions, like, do you have any actual evidence that just because I'm physically in Arizona, your rules apply? And he said, that's way above my pay scale.
Yeah. And this is great to have, because when you go back to court for your next hearing, too, you could bring this up. Hey, look, I went to city council and I asked them the same questions I'm asking you here. And either you're getting different answers, or you're getting, or you're getting stonewalled like you are, where, we're not going to discuss this. So you're really adding to your own case more evidence that they're not dealing with you fairly and honestly. And that's the big problem in these courts, is that they want to tell you that you are entitled to a fair hearing, yet when it comes down to actually giving you a fair hearing, they're refusing to do it. So you just want to constantly build that case. Bring these questions up to as many people as you can, and get all those same fallacious answers, and that just only strengthens your position when you go back to court.
Right. Well, I was adjudicated guilty today, so on all 4 counts. So I was just going to go ahead and file an appeal saying that I didn't receive a fair hearing and that I wasn't able to attack the evidence.
Right, but you can do that first in a motion to reconsider or to vacate the judgment based on a lack of evidence, lack of a fair trial, and you can also get with me after the show and I'll send it to you. When you do an appeal, there's no argument. It is really just a notice of appeal, and the notice of appeal is what gets it all started. So after that's filed and processed, then you'll get a briefing schedule, and then you can do that, and I can also help with that. So I'm sorry to hear that happened, but it sounds like you did a decent job. But
I tried. I've been listening to your radio program for a while now, and not that I'm out there looking to cause fights with the cops or anything, but I mean, I do want to stand up for myself and stand up for people in my community that are just getting bullied by gangs of killers, thieves, and liars.
Yeah, well, let's start with a county commission, confront them there. But we'll get the paperwork done to hopefully clean this up. But look online, find out when the next commissioners meeting and let me know. And if some of the videos I have, the questions written out, but you can get me after the show and I'll write them out again.
Okay. And how do I get the motion to vacate?
Just email me after the show and I'll send it to you.
Skype you?
You can Skype me or you can email me.
Okay. And your email's on the website, right?
It is.
Okay. I'm not too good with Skype, so I'll just go ahead and email you.
Okay, that works too.
All right. Thank you.
All right, we'll talk to you soon. Sorry to hear that had happened, but we are dealing with crooks. And few people say that that's my default position, that when my garbage inevitably loses in court, I can just fall back and say, well, but they're crooks. Because what they never do is they never address the actual facts and arguments that were raised. They just look at the judge denied it and like, but what about the merit of what was presented? What about the fact that the judge here, like for example, he could not attack the evidence?
Yeah, there goes your fairness right out the window.
Yeah, and so they don't look at that. All they do is think that the be all end all of my work is whether a judge has accepted it, and even when they do, they really haven't.
Right? Yeah. When the judge does accept it, then it's just metaphor after that. Just say whatever you can to not accept reality. Which,
yep.
I'm sure this guy lives on a ranch with unicorns, and
something's going on there, and I don't have the wherewithal to keep going day in and day out repeating the same thing. So,
well, speaking of repeating the same thing, why are they criminals? Because sometimes people give you a lot of flack for saying that because they force you to pay them.
Well, they actually claim that I'm just saying you're not the boss of me, that I'm just making a claim up that I don't like them and that, you're not the boss of me. Excuse me, it's always got to be a damn insult. Never address the actual facts. They're just men and women. They force perfect strangers to give them money. They have a prison system. That makes you a criminal.
Right.
End of discussion. Everything else is just public relations to blind you from that. Those are the facts. They never deal with the damn underlying facts to support my conclusion. They just ignore it. Oh, that's not.
Well, isn't that fundamentally why the mafia is criminal? Is because they force their clients, their businesses, their victims to pay them. I mean, if it's true for them, why is it not true for these little angels that sit, on stands in black robes?
Right.
Why are they not subject to the same standards that they hold other people to?
Double standard. So we got Dylan on, right? Dylan, you with us?
Hey, how's it going, guys?
It's going well. And this is another thing. No one can accuse me of cherry picking and only putting success stories on the show.
Oh, we've had our train wrecks.
Yeah.
When have we ever backed away from?
It's just another false claim that they make. Sure. I only cherry pick it, but
it's reaching because you have nothing else. Oh well, they just
So Dylan, I've already given away why you're calling. I know you did not have a good, just like our last caller, John. Things didn't go too well in court today.
No, I mean, I don't know how much better they could really go, aside from him, granting my motion. But
well, where did this happen?
This is Kalispell, Montana.
Oh, that's right. Okay. Yeah. Well, that's right. But the audience didn't know. Did you have Judge Sullivan or Allison?
I sure did. I had Judge Sullivan.
And did he pretty much stick to the program that we talked about, that he was going to just deny everything without explanation, not allow cross-examination?
Well, it was just my proceeding where he was trying to get me to plea. So
okay. Got it. Okay, well, so he probably wound up pleading not guilty for you, right?
He sure did. Yeah.
Oh. Well, okay, so what we like to do is, and I talked to you about this the other day, is we use the unsigned plea of guilty if they deny the motion to dismiss. So did he deny the motion to dismiss with no explanation?
So he did. So he said the motion wasn't actually filed yet properly. I mean, I had a copy right there that I gave to him. He made a copy during the proceeding, but he said that the motion wasn't on the table because apparently the mail hadn't gotten to them yet. They probably have it now. They probably just received it later in the day. So he basically acted as if the motion wasn't on the table, even though I brought it up multiple times, asking, basically saying that, the prosecution hasn't submitted any evidence to overcome my motion. And he just kind of pretended like it wasn't on the table, I believe, trying to recollect it properly. But so I pretty much had to go on like it wasn't on the table, but still use the typical tactics to try and get him to.
Okay. Did you use the unsigned plea of guilty that if the prosecution had met their prima facie burden, you would plead guilty?
Yes, and it's exactly like that. But yeah, okay. So I had this judge's ethics scorecard that I think it was Gabe or Kevin sent me. Those guys helped me out last night with some role playing. Thank God, because I would have done probably really poor. It's been a long time. And one of them sent me the judge's ethics scorecard, and I was really surprised to have gotten all the way through to number 8, which is, has the prosecutor described or submitted any evidence as of now that would justify this court imposing on me. And that's where things... What did he say? I can't even actually recall what he said to that.
Oh, that's important. Did he divert attention? Did he say the prosecution would have to prove that at trial?
Yeah, he made comments like that multiple times, that this is something the prosecution would have to do.
So basically, so for those listening, what the judge is basically doing there when they say that they only have to prove that at trial is they're saying that they don't have a prima facie burden to establish that the court has jurisdiction to even set it for a trial. Same playbook.
Yeah.
It doesn't matter if it's in Montana or it's in Florida, or whether it's in Toronto or it's in Brisbane. All the same thing. So okay, so
yeah.
The judge. Okay, so what did the judge just get snap at you that he's pleading not guilty for you at that point?
Well, towards the end, we kind of went roundabout. So I was doing pretty decent at catching him when he would say something that relieved the burden of proof off the prosecution. I'd kind of call him out on it, like, and I think it was to. I think he had said at one point that the prosecution did submit evidence because I had nailed him with, or if they haven't, then.
Starting to get a little all over the place now. Did he say that they had evidence, or that they would have to do that at trial?
I want to say in the beginning he said that they didn't, but further down the line he said that they didn't need to provide it. When I basically called them out on the fact that they didn't have any on the table.
Okay, and so a proper objection there would be objection. Are you proceeding knowing the prosecution hasn't established jurisdiction?
Also, are you allowing the prosecution to argue without evidence? If he's saying that he doesn't need it, then he's essentially saying that the prosecution doesn't need evidence to prove their argument, which is, like we covered earlier, just one major count of misconduct.
Yeah, so when it came down to it, he was saying that it was the complaint that he had, which somebody had mentioned earlier. I should have asked. I didn't have it in front of me and asked to see it, but I did ask, where in the complaint is the facts that prove that this court has jurisdiction. And I think he went with the officer's testimony, and I questioned him as to, what part of the officer's testimony as the facts to prove that the codes and the statutes are applicable.
That's good. And what kind of response did you get? Do you remember?
I ended up a little flustered, and it kept circulating around this one idea, and I don't remember. At one point he was saying, "I already answered your question." He's basically accusing me of not listening or whatever, and maybe I wasn't. I was getting pretty overwhelmed. Never really got to that point. So I don't remember exactly what he said. He was just focusing in on, and it was in the complaint. It was the officer's testimony. I got to listen to the recording that we got and refresh my memory on how it actually all went down, because I did a pretty decent job.
That sounds like you did pretty decent your first time out. Obviously, for those listening, when we hear the officer's test, and now you've got him because you can go back later in a pretrial conference. And you say, well, the judge said, you said that the evidence was from the officer's testimony. What on this ticket leads you to believe it's evidence proving the Constitution applies to me? That's why they don't like getting specific, because it's too easy to call them out on their BS. Well, okay, show me. What's he gonna do? Hey, well, the complaint's a metaphor. Hey, it's a metaphor. What is the matter with you over here? Doesn't do justice to try to do the whole Jersey thing,
Well, you don't hear that kind of garbage.
Yeah, it was
in
interesting.
Jersey. You hear a lot of garbage, but not metaphors.
Yeah. So it ends with him pleading not guilty for you.
Yeah, he says he basically said that I had already answered my questions, and of course I was objecting and saying, what facts are in the officer's testimony on the complaint that prove that the codes and statutes this court has jurisdiction to. I keep forgetting the term that we were using in the role playing last night, but not preside over me, but
have jurisdiction over me to get probable cause to arrest me, or charge me.
Right. So I just kept going at that, and he, I was kind of interrupting him by objecting. He started asking me for my mailing address to just go ahead and put the plea in for me. And I objected, and I said, I used it multiple times. I said, I have an unsigned plea of guilty right here. My intentions are to plead guilty. You just provided me with the information the prosecution provided. And like I said, he just kept saying that he already answered me.
Yeah.
And started asking me for my mailing address, and I wasn't giving it to him. I just kept objecting, and it came to a point where he called the bailiffs in,
Oh yeah.
He told them to take me away, and they put the cuffs on me and everything. And I was like, all right, what do I got to do? I don't want to be thrown in a cage. I don't want you to use this violence against me.
Wait, the thing is, Dylan, you had to put the mailing address on the motion.
Right. Yeah. So it was on the motion that he copied and stuff.
Yeah. So it was, either he obviously didn't read the motion. We know that. You could have just said it's on the motion, so you could have avoided the cuffs. What I think is interesting, because when we spoke the other day, I had to write down one of the statements you said that the cop gave you when you were asking the police officer for his evidence to support his claim that just because you're in Montana, the rules apply to you, the Constitution. And you said, I do this every day.
Yep,
that's what the cop said to him.
That's facts and evidence right there, right?
There you go.
What else do you need?
Case closed.
You do this every day.
How many times have I heard tax agents, I've done this for 23 years.
Right.
Well, then you should be able to answer the question.
That's what facts and evidence look like.
Yeah.
I do this every day.
I do this every day. That's prior testimony, so you definitely want to bring that up on cross if you get that far in this. So... you still can strike the testimony, strike the plea, because you weren't refusing the plea. You just wanted to see the evidence. The judge said it was on the ticket, but it's nowhere to be found. The judge is obviously trying to mislead you so that he can just get you out of there.
Yep.
So that's what I would do, and I would definitely get ready for a pretrial conference with this prosecutor, who you and I may actually, we might actually speak to one of these guys. We've dealt with this Judge Sullivan before.
Oh, is it with another client?
Yeah, Peter.
Okay.
Peter was from Russia. A nice guy.
Oh, I remember him. Yeah.
So he would call in, and he dealt with the same one. And so when we were talking the other day, Dylan and I looked up. And I said, "Oh yeah, not gonna be surprised." So yeah, I do this every day. Yeah, that's a strong witness. Wouldn't you think, Dylan?
Yeah, it's great.
All right, well, we are out of time, so what we're going to do is get with me again off air, like with John in Florida, and I'll send you the paperwork that you can edit and send out. And then what we'll do is we'll work on an appointment that we can make so we can give, I forget his name, but the prosecutor. And, we can call the prosecutor's office and see who's assigned and can ask some questions and see if he's going to back the police officer. And, well, he does it every day. No.
Right.
Yeah,
I do a radio show.
Filing the complaints every day.
I do a radio show for 4 hours a week. I've done it for years. I do it, not every day, but I
do this every day.
I could. I certainly. Well, hey, Dylan, I appreciate the call, and sorry it went that way, but we knew about Sullivan already, and that it was going to be a tough road, and it's going to continue to be, depending on what happens with this prosecutor. And but we'll definitely get you prepped for court so that if you have to appeal it, that you'll have some pretty strong issues, just like John in Florida.
Sounds good. Thanks, everyone, for the help.
Yeah, appreciate the call. And the help he's talking about, we have Dylan on the No State Project Skype chat, which you can get into at markstevens.net. There's a link directly to it. I think you're the one who did that.
Yeah. You put that on the website. Therefore, it's a little easier to get right in.
And
takes a lot of the guesswork out of it.
There's good and bad to that, though.
Well, as with all things, but the good part is that anybody can easily find it and get in there.
Yeah.
So
we actually have 371.
Hey, look at it. And I don't know what's happening with Microsoft. They're actually writing their software to allow more than 300 people in there, so good on them there. But yeah, it's a lot of people helping each other out. So the questions are real simple, and it makes it easy for us to help each other out and keep the prosecution of their burden of proof. They're making these claims. All we're doing is asking them what evidence they have to support their claims, and that's where the role playing comes in. So everybody, even if you're seasoned, is encouraged to at least participate. And if you're seasoned, take on the role of the prosecutor or the judge and really put the newer people to task so that when they go into court, they're not fumbling where to go with their questions or how to respond to their nonsense, where they could ask leading questions to actually get the truth out of them and to get what they're saying out of them, or to expose that what they are saying is they essentially don't have the evidence that they're supposed to have.
Yeah, and I want to point out, too, there's three roles that are being played. Someone's playing the judge, someone's playing the prosecutor, and then there's you or the defendant. You should not be doing the role playing as just one. You should be taking turns, and everyone should be shuffling, whichever job that they're doing, so that you can get in the mind and try to anticipate the stupid things that are going to be coming out of their mouth. So definitely do the role playing, and Dylan and John definitely get to a city council or a county commission.
Well, the more familiar you are with it, the better you're going to be. And to do all those roles, to be familiar with it, if you're going into court, you have to take it seriously, and you have to be able to anticipate where they're going to go. So whether it be going into city council, which is good, because there you are in kind of the mini lion's den, or whether you're actually in arraignment, it's good to actually have that practice. So, get the role playing in and know what they're going to be throwing at you, and know it from all sides, like Mark was saying. Have a feeling and a sense of what the judge is going to be bringing to you, and what the prosecutor is going to be bringing to you, which is pretty similar, and what you're going to have to be countering.
Yeah, say I'm a con man when I suggest that people collaterally attack the prosecution's burden and not accept the sacred cow is just dishonest to say that that's not an effective strategy. He actually slipped at one point and complimented me, said that's a good strategy. But then he went right back to the other crap. So he had a momentary lapse of
reason
of crazy, and he was very lucid for that one thing. So that's all we're doing. Yes, you are calling into question the legitimacy and the fairness of the whole system, but you're under attack. So not everyone's an activist. You want to just limit the amount of damage that's being done, and I appreciate that. We're still going to practice and do the role playing, and still we have the added benefit if you're going to a city council meeting, because other people can be educated, in addition to the fact that you are so much more comfortable going, because when you go to court, you might not have more than a few people there. You go to a city council meeting, you could have 200 people.
Yep.
So if you could do it in front of 50, 60, or 100 people, and you should be able to do it with just 10 or 12 in court.
Sure. Yeah. It's a good starting point.
You can't. Everyone who's gone through this, I think when there was a comment on this show today, I think Dylan made it that you have to do the role playing. That there is a big difference between the two. So get the role playing done. Get the basic principles down. You're asking questions to the accuser who bears the burden of proof. You're not giving him a sacred cow, and you're going to ask leading questions to bring out their contradictions, because they're full of crap. And when they start frothing at the mouth, this verbal diarrhea of philosophy or metaphor, you got them.
You're asking the right questions.
Yeah, you've backed them up against the wall. You've shown they are dishonest. They're not credible. They cannot support their claims, because I'll say it every damn show, that which can be asserted without evidence can be dismissed without evidence. Right. So again, if you're being attacked, definitely check out the No State the show. We do 4 hours a week. We will be live this Saturday again, so check that out.
And just before we close, statistically, I just want to throw this in there for this show here. Statistically speaking, we've had more successes from those who have actually engaged in role play than successes from those who have not engaged in role play. So that's why, from a statistical perspective, why it's important to actually engage in role play. Because if you're going to court, we're assuming that you're looking to succeed, to actually have things come out in your favor. So if that's the intention, statistically speaking, get in there and do what you need to do to be prepared, so that you can actually have some level of success of exercising effective damage control.
Yeah, you have to be prepared. You have to do the preparation. So if you are being attacked, markstevens.net, check out the archives of the show. Call into the show. And in Government Indicted, have a full model on how to do this that has proven, regardless of the critics, that, whatever, Fangul, show me where I'm wrong, and we'll if I'm wrong, I do correct it.
Sure.
Greg in I think I mentioned earlier, his appeal on the face of it had to do with there was no transcript. The vendor for the that the prosecutors used, or did not send the transcript as ordered. Throw it out. Again, it could have been because they just didn't want to deal with the issues because it was pretty clear cut. Denial of cross-examination, you can't justify that. So we have had success. We're going to continue replicating the success and want to continue discrediting them at city council meetings or whatnot. So glad to have you here. I think we're going to get more call to shames. We'll be able to do that. But this has been episode 29 of the No State Project on Wednesdays. So it's August 9, 2017. We'll get this up hopefully by tomorrow. I might actually have this horrible stream up tonight. I could actually have that within the hour, but we'll see. We'll definitely get the audio up tonight, and we will be live on Saturday. So, to then, salud.